What will happen if both parties in a divorce want the marital home, but only one can afford it without outside assistance? When only one spouse can realistically afford the home on his or her own, that spouse is often awarded the home. That makes sense. If one spouse can afford to refinance the mortgage in his or her sole name and buy out the other spouse's share of the equity, or buy out the other spouse's equity share by receiving fewer other marital assets that put him or her in a much stronger position to be awarded the marital home. If the buying spouse does not refinance and buy out the other spouse, or does not otherwise buy out the other spouse's interest within a reasonable time frame set by the court may order the home sold and the equity proceeds divided between the spouses. Desire to keep the house does not matter if one can't afford to pay for it. Even if one claims an emotional need for the house, or even makes a good practical argument, for example, to keep kids in the same school district, the financial reality is what ultimately controls. It must. That stated, if, for example, the home is the children's primary residence and continuity and stability is in their best interest, that may sway the court slightly, but again, only if the parent who stays in the home can afford the home. Judges don't like creating ticking financial time bombs. Courts just don't award homes to people who can't afford them, or at least they try not to, because doing so risks later default, contempt motions, and just more litigation.